what I'm going to try to talk about is the usefulness of neuroscience to criminal law, to the criminal justice system. And if I frame that in terms of a question, it would be, is neuroscience useful to the criminal justice system? And my answer would be, not very. And basically it follows directly from what Dr. Fellows just finished talking about. I'm going to talk about this through the prism of the rules of evidence, because I think that speaks most to what you all do for a living. So what I'm trying to do is draw together a lot of what went on today and talk about it through the framework of the evidentiary rules. As judges, you have to decide whether the kind of stuff we've been listening to today is admissible, whether it should go to the fact finder, whether that fact finder is the jury or you. So I think it might be useful to start off by looking at how frequently neuroscience evidence is introduced into criminal cases. This is a study done by Nita Farahani at Duke Law Review. She looked at all reported cases between 2005 and 2012, and as you can see, she saw about 1,500 cases in the reported literature. And you can also see that a lot of this neuroscience evidence was introduced at sentencing as opposed to a trial, but quite a bit of it was also introduced at trial, which is somewhat surprising. Basically an average of about 200 to 250 cases a year. About a third of these cases were involved in capital offense. And in fact, neuroscience is introduced in about 25% of all capital cases. If you want to find testimony about neuroscience, go to a capital case, and you're going to see it more often than not, or at least quite frequently. So whether this information should be getting into the criminal courtroom, I think, needs to be answered by looking at the rules of evidence. Or at least it can be answered that way. And I think looking at this issue through the rules of evidence is a very useful way of trying to figure out how helpful neuroscience can be in criminal court. Now, you're all familiar with this framework. It comes from the Federal Rules of Evidence. I'm obviously aware of the fact that the rules of evidence are quite seriously relaxed at sentencing, but as you saw from the slide I just showed you, quite a bit of this evidence does get into a trial where the rules of evidence are applied fairly rigidly. And I think discussing admissibility rules is helpful even in terms of talking about what should be useful at sentencing. So I want to go through this with the thought in mind that all of this can be useful not just at trial, but also at sentencing. So this is the evidentiary framework you're all familiar with. Let's say we have a qualified expert like Dr. Fellows who's going to talk about frontal lobe damage, some kind of damage to the brain. The first question we have to ask ourselves is, does this in any way logically relate to a proposition in the criminal case? Second, we have to ask ourselves, what is the probative value of this evidence? And this is a measure of reliability. When we're talking about expert testimony, that question is usually answered by reference to either the Frye criteria or the Dauber criteria, depending on what jurisdiction you're in. Assuming evidence is material and probative, and if we're talking about expert testimony, we also have to show that the evidence is helpful. That is, it has to add to what the fact finder can figure out for itself. You can have material and probative evidence that's not helpful to the fact finder. Why? Because it's so obvious. We don't need an expert to tell us what's going on. And then finally, even if evidence is material, probative, and helpful, it might be inadmissible if it has a significant potential for distracting or confusing or in some way unduly influencing the jury. You're all familiar with this. I'm only going to talk about, the first issue here, materiality. I'm not going to talk about probative value, helpfulness, and prejudicial impact. We might have a chance to talk about that in Q&A, but I don't have enough time to talk about all four of these factors. The reason I'm focusing on materiality is not only because of time constraints. I think often materiality can be the dispositive question in these cases. And I also think it's the issue that's most frequently ignored by judges who are deliberating on the admissibility of neuroscience evidence. And I want to talk about the materiality issue using two different cases. And this is the wrong slide. Shoot. This is the wrong program. Okay, well, I'm going to have to see what happens here. I have two different cases I want to talk about. One is the Oft case, which Dr. Fellows mentioned. It's in your materials. This is the case involving the individual who, while he had a tumor, seemed to have very strong sexual urges, was soliciting complete strangers to engage in sex and so on. I'm going to assume that before his tumor was removed, he molested a child. He engaged in child molestation. And as you know from what Dr. Fellows said, after the tumor was removed, all the sexual interest disappeared, and he no longer engaged, we'll assume he no longer engaged in this kind of behavior. So that's the first case I want to talk about. The second case I want to talk about is the case of Mr. Neri. I hope you see the literary allusion here, Mr. Oft and Mr. Neri. Okay. This case is actually based on a real case out of California, the Chiesa case, individual charged with 2 counts of first-degree murder. And apparently what had happened is he had gotten into arguments with these 2 individuals in the past about property matters. On the day of the killing, he called up the police. and said, "You better get over here pretty quickly because these two people are trespassing on my property, and I'm about to do something." Then he gets in his truck, drives over the two people, and shoots them dead. Okay. Subsequently, experts did PET scans and CAT scans of, boy, this is a totally wrong slide. I'm very sorry about this. I'm just going to take that off because it'll confuse you. What happened subsequently in this case is that the experts did a PET scan and a CAT scan of Mr. Neri's brain, and they found frontal lobe damage, or what I'm going to summarize as FLD. And they also testified at trial that this frontal lobe damage meant that at the time of the crime, Mr. Neri had a very hard time controlling his behavior, that his impulse control was seriously compromised. Okay, so I'm only going to talk about materiality with respect to the Oft and Neri cases. And what I want to say basically is this, that the kind of brain damage that was presented in both these cases is probably immaterial in most criminal cases, not only at trial, but probably in most sentencing proceedings. At least that's the proposition I want to put forward. And by the way, I'm only going to talk about neurological evidence that looks at structural damage of the type Dr. Phelps was talking about. I'm not going to talk about brain imaging data, which, brain function data, which opens up a whole new can of worms, and it's much more difficult to talk about in terms of materiality. So, I think in terms of talking about materiality, we need to think about both, two different kinds of materiality, or fit. Those of you who know Daubert know that Daubert uses the word fit to address the materiality issue. The first kind of fit or materiality I want to talk about is legal fit. And the second type of fit I want to talk about is empirical fit. Okay? So what do I mean by legal fit? It's the extent to which the evidence, in this case neuroscience, is logically related to a recognized legal doctrine. So, in a criminal trial, neuroscience is most likely to be material to one of the doctrines you see up here. And you're all familiar with these criminal law doctrines. The involuntary act doctrine, the argument that the individual didn't have the mens rea for the offense at the time of the crime, and then of course there's the insane defense, which can be based either on cognitive impairment, that is an inability to appreciate the wrongfulness of one's conduct, or volitional impairment, a substantial inability to control one's behavior. And I think it's fair to say, at least with respect to the first three doctrines, the evidence of brain injury probably is immaterial. Starting with the involuntary act doctrine. This doctrine requires the defendant to show that there's essentially no link between the brain and the body, as with an epileptic seizure. And it's pretty clear that both Mr. Oft and Mr. Neri did have control of their physical movements. They're not going to have an involuntary act defense. Doesn't matter what kind of frontal lobe damage we have. Behavioral information tells us very clearly that they did have control of their physical movements. Similarly with lack of mens rea, the behavioral information tells us that both of those individuals intended to do what they did. In other words, Mr. Oft intended to molest a child, Mr. Neri intended to kill his victims. Now Mr. Neri might have a lack of mens rea argument with respect to the mens rea for first-degree murder, if that mens rea is premeditation, depending upon what the definition of premeditation is. I want to come back to that in a second. But for the most part, as Steve was saying earlier, most people, no matter what kind of image we have on the screen with respect to the brain, no matter what we know about functional brain imaging, are going to intend that the acts they commit. So there's usually not going to be a lack of mens rea defense. What about insanity? Well, with respect to insanity, of course, the predicate is whether or not there is a mental disease or defect. And so a judge is going to have to decide, first of all, whether frontal lobe damage is a mental defect. That's the first thing that has to be decided. Assuming it is, then we have to look at whether that caused the kind of cognitive or volitional impairment that's recognized in the insane defense. Well, it's very unlikely either of these individuals, behaviorally speaking, are going to meet the cognitive impairment test of insanity. If you looked at the materials, which I'm sure all of you did, right? You all did your homework, you looked through all the materials, you know that Mr. Oft tried to hide the evidence of his sexual exploits. I mean, he knew that what he was doing was wrong. And we see evidence from the Neri case as well. Remember, he called the police. He knew that what he was about to do was wrong. It's very unlikely he has any kind of cognitive impairment defense in connection with insanity. On the other hand, with respect to volitional impairment, at least Mr. Oft might have some kind of excuse. Because again, this is the individual who, when he had the tumor, had very strong sexual impulses, apparently. When the tumor was removed, those disappeared. So it suggests that the neuroscience evidence suggests that there was a significant difficulty in controlling behavior as a result of this tumor. On the other hand, unfortunately for Mr. Oft, only about 10 jurisdictions recognize this component of the insane defense. Only about 10 jurisdictions recognize an insanity defense based on volitional impairment. In the federal courts in Tennessee and over 30 other jurisdictions, only a cognitive impairment defense is recognized. So Mr. Off is out of luck in almost all jurisdictions. What about Mr. Neri? Let's assume that he is in a jurisdiction that has a volitional component to the insanity defense. He's still in big trouble. I mean, first of all, he can't show, like Mr. Off can, that if his frontal lobe damage was somehow repaired, he would no longer be violent. He can't even show that his FLD caused the crime, at least based on the neuroscience data. As Dr. Phelps was saying, it's very hard to show that causative link between brain damage and particular kinds of behavior. But even if you could show that the FLD caused his behavior, causation is not an excuse. As Professor Morse has argued, causation couldn't be excused, and here again my slides are abandoning me, but causation can't be excused because if it were, or causation can't be compulsion or excuse, because if it were, every case would have to result in acquittal. Every case would have to result in excuse because virtually every crime is at least in part the result of factors over which a person has no control. Just think about it. There's research showing, for instance, a correlation between violence and child abuse, a correlation between violence and having a violent adult role model in the family, a correlation between violence and low serotonin levels. We don't excuse in any of those situations. Why should we excuse just because a person has frontal lobe damage? Causation is not compulsion. Causation is not excuse. And so it's very unlikely that at least Mr. Neri is going to have any kind of legal defense based on frontal lobe damage, at least at the criminal trial. And that's probably going to be true as well, even at sentencing, at least if we're talking about a non-capital sentencing proceeding. At least for those of you who work in federal court, you know that volitional impairment usually is not grounds for a downward departure if the crime is violent or involves a threat of violence. So in Mr. Neri's case, assuming it's a non-capital case, this evidence is going to be immaterial. Now, on the other hand, in capital cases, basically anything can be material, right? Supreme Court said anything could be a mitigator, and that's why we see so much of this evidence being presented in capital cases. The problem here, of course, is the familiar double-edged sword problem, that if the jury hears that a person is having trouble controlling his behavior based on neuroscience evidence, behavioral evidence, what they're possibly going to do is find the individual to be dangerous. And unfortunately for these kinds of defendants, in most states that have the death penalty, dangerous is actually an aggravating factor. So this neuroscience could be used as an aggravator as opposed to a mitigator. So bottom line is, there's a pretty weak legal fit between frontal lobe damage evidence, evidence of structural damage in the brain, and anything that might be presented at a criminal trial, either the trial or sentencing stage, except for at capital sentencing, but then you've got the double-edged sword problem. But that's not the only problem. I've talked about legal fit. What about empirical fit? What do I mean by this? This is the extent to which the scientific research, which the expert is relying on, fits with the facts of the case, whether it's logically related to the facts of the case. And there are at least two ways in which scientific research might not have good empirical fit in a criminal case. The first problem is what some colleagues of mine and I are calling the G to I problem. Okay, the G to I problem, which stands for the difficulty of applying group data to individual cases. Professor Jones alluded to this morning, and it's one part of the MacArthur Research Network. What we're trying to do within that network is deal with a problem that afflicts all scientific evidence, or almost all scientific evidence, when it's presented in a criminal or civil case. Almost all science is based on study of groups. You've seen that all day long from BJ and everyone else. Of course, what courts have to do is try to resolve individual disputes. And sometimes it's very difficult to apply that group data to individual cases. Dr. Fellows was alluding to this a little bit earlier, so I'm not going to belabor the point. But I do want to give two examples of the kind of research you may have seen in your courtrooms or could see in your courtrooms to try to expose how there can sometimes be some flawed thinking about this G to I problem. And the first example is what I'm going to call the Bryant study, which is a study that was done in the 1980s. And I'm calling it the Bryant study because that was the name of the lead author. Very interesting study. What it found that a violent offender is about 2.5 times more likely than a nonviolent offender to have FLD, frontal lobe damage. This study looked at 110 prisoners, 55 of whom had committed violent offenses, 55 of whom had committed nonviolent offenses, otherwise matched pretty closely. And what it found is that 73% of those who committed the violent crime had FLD. Only 28% of those who committed the nonviolent crime had FLD. Well, this sounds pretty exculpatory, at least in your jurisdiction that allows volitional impairment to be a defense, but it's not. It's basically immaterial. Why? Because this is only telling us How many, it's only telling us how likely it is that a person who's been violent has FLD. Okay? It only tells us what philosophers call the cause of an effect. It doesn't tell us how likely it is that a person with FLD will commit a violent crime. And that's what the law is interested in. Okay? Or the effect of what philosophers would call information about the effect of a cause. The law is interested in other words, the extent to which a particular neurological problem or any other kind of problem contributed to the crime. And this kind of study doesn't answer that question. And the reason I'm making a big deal out of this is that courts are often presented with this kind of information about the cause of an effect. Decades ago, defense attorneys were very fond of introducing scientific evidence that showed that people with an extra Y chromosome were overrepresented in prison populations. And today we're seeing testimony that people with psychopathic personalities are overrepresented in prison populations. That tells us nothing about the extent to which a person with an extra Y chromosome or a person with a psychopathic personality is likely to commit a violent crime or a crime at all. What we need is other kinds of research, for instance, prevalence research, which does look at the effect of a cause. This kind of research is at least tangentially useful to the legal question, which is how much did a particular cause contribute to a crime. And what we have in terms of prevalence data is data that shows that people with FLD are about 10% more likely to commit violent crime than people that don't have FLD. So there's a slight predisposition on the part of people with FLD to commit violent crime, but not much of one. So it's not very helpful. And as usual, you also have to look at this group data in context. The violence prevalence rate among the general population is only 2% or so. So what does this prevalence data about people with FLD tell us? Well, there's about a 2.2% chance that they'll commit a violent crime. That's not very material to any kind of criminal litigation. It's virtually useless. And this is why I'd argue that even looking at empirical fit, this kind of data, even assuming there's legal fit, and just looking at empirical fit, this kind of data is not very useful in a criminal case. So that's the first kind of empirical fit problem. The second and last kind of empirical fit problem I want to talk about, I'm going to skip over the fMRI stuff, is external validity, what Dr. Fellows was referring to as ecological validity. And I think you've probably heard a lot about this already today. A lot of this research, whether it is brain imaging, fMRI, or research looking at brain structure, uses very small samples, often using college students or judges or somebody like that. It's very hard to argue that that kind of research is generalizable to a criminal offender population. And there's very low ecological validity to this kind of research. Now, on the other hand, if you look at the Bryant study, has pretty low materiality for all the reasons I talked about, but at least their sample is generalizable to the people we're interested in. It did look at offenders, right? And it's a pretty large sample as these studies go. And the prevalence research also involves pretty large samples. But even if you can overcome that particular problem, it's very important for judges to also pay attention to operational definitions. So I'll just give two examples based on the research that we're talking about here. First of all, how did the researchers define FLD? Okay? If, for instance, it's a very narrow definition, if, in other words, the researchers in the Bryant study define FLD as fairly major impairment, I'm not even sure what that would be. Just a whole bunch of damage in the frontal lobe, or not so much. And we're trying to apply this to the Mr. Neri case. And let's assume he doesn't have major FLD. He only has minimal damage to the frontal lobe, whatever that might mean. Then this research might be totally immaterial to Mr. Neri's case. Another operational definition problem is the definition of violence. If these researchers define violence very broadly to include simple assaults, it might tell us nothing about the relationship between FLD and serious crime, like Mr. Neri committed. So in other words, there are lots of problems with applying any kind of empirical research, not just about neuroscience, but really about any science, to a criminal case. And I hope I've illustrated what some of those are. I'm sorry for the problem with the slides. I'm giving you an old version of the slides I had. I thought I brought the new version, but I hope it made sense as I went through all of this. I will be glad to talk about the probative value issue, the helpfulness issue, and the prejudicial impact issue. I think very interesting things can be said about all three of those issues as well, but I wanted to make sure I adhered to my time limit. So I'm done. Thanks.